Hello, I'm Helen Good, and I'm part of the Elizabethan Star Chamber project, which is trying to make sense of the National Archives class STAC 5. And I am joined by some of the wonderful and talented members of the Beyond Shakespeare Company who have kindly once again agreed to read some more Star Chamber with me. And following the Beyond Shakespeare method, we're just going to read and then discuss. And our readers today are Alan.
Hi, Alan, based in Suffolk.
And Liza.
Liza Graham, actor and singer in London.
Sarah.
Sarah Blake, actor, writer and director based in Germany.
Emma.
Hello, I'm Emma Kemp. I'm an actor and I'm based in London.
Rachael.
Hi, I'm Rachael, actor on the East Coast.
And finally, but by no means least, Eric.
Hi, I'm Eric. I'm nobody else.
And today's case is Clerk and Smoote, which is from Nottinghamshire in 1592. And if Eric could begin the bill of complaint.
To the Queen's most excellent Majesty, most humbly complaining, showeth unto your most excellent Majesty, your Highness, obedient and faithful subject, John Clerk, of your Highness town of Nottingham, in the county of the same town, parchment maker, that whereas your said subject, by the space of 20 years or thereabouts, hath used and traded the art and mystery of parchment, so it is, if it may please your most excellent Majesty, that about 9 years now, about 9 years now last, one Christopher Turner, William Barton, and Leonard Williamson, in the name of themselves, and of one Thomas Wilson, John Hanley, Thomas Tomlinson, Henry Pybus, John Richardson, Rafe Nutkin, and James Crosby, being, as they affirm, parchment makers and dwelling in the city of York, did about the 25th year of your Majesty's reign come unto your said subject, unto the said town of Nottingham, and did there tell him, your said subject, that they, the said Christopher Turner, William Barton, Leonard Williamson, and the other persons last before named, had a special grant and license unto them granted by authority from your Highness, only to make parchment, and that all such parchment as your said subject made, were it never so good and merchantable, were yet forfeited unto them by reason he had not the like license to make the same as they had.
Whoa. Now then, what is happening here? Sarah.
I don't know if I've got this right, but basically a whole bevy of parchment makers from York have turned up in Nottingham and told the guy who makes parchment in Nottingham, who's called John Clerk, who's been making it for 20 years or thereabouts, that he can't make it anymore because they've got a license and he hasn't. Is that right?
Yeah, it seems to be. I mean, this is not an unlikely scenario in that such small monopolies were handed out. But the idea that York should control Nottingham parchment making does seem a little unusual. Sarah.
So that didn't happen very often then, that the monopoly in one city was also given jurisdiction over another? That wasn't like something that happened.
It isn't impossible. And very, a courtier might be, there was a courtier given the monopoly of salt making in Hull, Boston and King's Lynn.
But they're all kind of quite near each other, aren't they?
Yeah.
So, yeah.
Well, York and Nottingham aren't that far away. But yeah, well, is it true or not is the question one has to ask. Alan, take the story on further.
And thereupon the said Christopher Turner, William Barton, Leonard Williamson, in the name of themselves and all the other persons before named, not having the fear of God before their eyes, nor regard of your Majesty laws in such cases provided, prohibiting such deceitful fraud and cozenage, did then very earnestly, fraudulently and deceitfully threaten your said subject to steal and take all such parchment as your said subject had ready made in his house, were it never so good and merchantable, except your said subject would enter into an indenture of covenants to be made between them, the said Christopher Turner, William Barton, Leonard Williamson, Thomas Wilson, John Hanley, Thomas Tomlinson, Henry Pybus, John Richardson, Rafe Nutkin, and James Crosby of the one part, and your said subject of the other part, and likewise would also enter into a bond of £20 for the performance of the covenants in the said indenture, contained being to this effect, that he, your said subject, neither any other person for him or to his use, should at any time after, during his natural life, make or cause to be made any manner or kind of parchment whatsoever, without the assent and consent of the said Christopher Turner and the rest of the persons before named, first had and obtained in writing for the same, which licensed by words they then faithfully promised to make under their hands and seals unto your said subject. Whereupon your said subject, being an ignorant and unlearned man, and giving faith unto their speeches, did before he was aware seal an indenture of covenants and a bond of £20, with condition for the performance of the same, made as well in the names of the said Christopher Turner, William Barton, and Leonard Williamson, as in the names of the other persons before named, of the one part, and your said subject of the other part, notwithstanding the said indenture was sealed only by the said Turner, Barton, and Williamson.
Okay. Now then, it is apparently a con. They have turned up on the doorstep of this parchment maker, who's obviously working from home. He lives, his workshop is at the back and his selling shop is at the front. And they have conned him into signing a covenant that he will only make parchment under their license. And with such a covenant would go a bond, because you've got to have the penalty. The covenant just makes the promise. The bond then says, this is what you will lose if you fail to follow your covenant. That having the two together would be perfectly normal. Alan.
And £20 would have been a significant chunk of an annual earning, would it not?
Yeah, I think so. £20 would be about half a preacher's salary. But then a preacher would expect to get extra for doing funeral sermons and stuff on demand. Sarah.
So it's possible this posse, because there's quite a lot of them, isn't there? They've been sort of going around, they might have been going around the country doing this, sort of like, just, because I'm intrigued that there's so many of them. It's almost like, I'm getting a little bit of a sense of like, oh, well, okay, what happens to the people who don't agree to take the license and yeah, give over the bond, because there's just such a lot of them. It's almost like Money with Menaces as well, is like a con.
He only sees a few of them. The rest are shadowy people in the background. I mean, they may be the York Guild of Parchment Merchants, and 3 of them have gone rogue. I mean, it would need someone who knows about the parchment industry, or who knows about York, or who knows about Nottingham to unravel this. But Eric.
Yeah, so basically back then they didn't exactly, well, it wasn't like sort of a database where, you know, like nowadays we have electronic databases for it. So obviously there could be no comparison. They would have no idea what was going on in New York. Well, I mean, I guess they would, but like by the time they got the news, it was kind of, yeah.
Liza.
Likely their guild would have a database. Their guild would have a register of people who were qualified and members of the guild. But information being quite slow at that time, it would take some time to go to the guild headquarters, ask to see the register, check if those names were on it, and then do something about it.
Yes. Yeah. So let us plunge further into the story. Eric, it's your turn.
Oh, isn't it Liza?
Oh God, sorry.
Yes.
Yeah, this is me again. Yes, it's Liza, of course.
By reason whereof the said Christopher Turner, William Barton, Leonard Williamson, Thomas Wilson, John Hanley, Thomas Tomlinson, Henry Pebus, John Richardson, Rafe Nutkin, and James Crosby, espying the advantage that your said subject stood bound to perform an indenture made by them all, whereas none such was, have therefore now of late, that is to say, about Michaelmas last, contrary to your majesty's laws in such cases provided, very unlawfully combined and confederated themselves together with one Laurence Smoote, being a very lewd and troublesome person, to the end that he, the said Smoote, for the gain of one half of the said bond by them promised in your names, should arrest and impleaded your said subject, which said unlawful champetry and maintenance, he, the said Laurence Smoote, hath in some sort hitherto confessed, affirming that if he could cast your said subject in the said suit, that he, the said Laurence, should have one half of the said bond to himself. The other moiety should be to the use of the said Christopher Turner, William Barton, Leonard Williamson, John Hanley, Thomas Tomlinson, Henry Pebus, John Richardson, Rafe Nutkin, and James Crosby, who had set him a work therein. Whereupon the said Laurence Smoote did afterwards, that is to say, about the 1st of November last past, in the name of the said Christopher Turner, William Barton, and the rest of the said parchment makers, arrest and implead your said subject upon the said bond, in your highness said town of Nottingham, and doth at his own charges pursue the same, in hope of having the one moiety thereof to his own use, contrary to your majesty's laws, prohibiting such unlawful champetry and maintenance, in vexation of your highness subjects.
Okie dokie. Shall I explain champetry and maintenance briefly?
Yep.
I looked them up again this morning just to make sure I had them right. Maintenance is supporting a law case in which you have no particular interest. So if you hate your next door neighbor, and somebody on the street is going to bring a lawsuit against them, you can go to that person and say, let me support your lawsuit with money or resources because I hate these people. And that is maintenance, and was then illegal. You could only get involved if you had skin in the game. Champetry is different. Champetry is that you say, I will sue these people on your behalf instead of you. My name will go instead of you in return for a part of the proceeds. You could say that lawyers doing their no win, no fee cases are guilty of champetry. But nowadays it's legal. But that's what champetry is, and it was not at this stage allowed. I think it probably happened all the time, but it was not generally approved of. Okay, any other Sarah.
So Smoot goes to arrest him in order to get half the bond. And what would he have arrested him for? I mean, it's not said, it's not specified. Have you got any sense of what it would have been? Like, what would have been his excuse for?
It would be for debt. What he would do is he would go to an officer, give him a small fee, and say, a bailiff, and say, please arrest this man for debt. Here is his bond.
Right.
And the officer would then arrest him on the bond.
Wow.
Yeah. Happens a lot in plays. Also, I'm told. But he is arrested by an officer.
Right.
This is always a tremendous inconvenience, because apart from the fact you've got, well, you can see how it could be somewhat inconvenient. All right, I have it down as Sarah to go on.
And further also, the said Laurence Smoote, bearing a malicious mind towards your said subject, being animated and set on by the procurement of the said Christopher Turner, William Barton, Leonard Williamson, Thomas Wilson, John Hanley, Thomas Tomlinson, Henry Pybus, John Richmond, Ralph Nutkin, and James Crosby, not having the fear of God before their eyes, neither regarding your Majesty's laws and statutes in such a case provided, he, the said Laurence Smoote, about the 3rd of November now last past, being accompanied with some other riotous persons, to your said subject yet unknown, did in the night season stand in the churchyard of St. Peter's in your highness said town of Nottingham, and did there watch your said subjects coming by. At which time your said subject, being in God's peace and in your Majesty's, and passing by that way about his ordinary business, he, the said Laurence Smoote, then standing in the said churchyard, and having in his hand a great staff, did suddenly in the said churchyard strike your said subject as he passed by reason of which battery he, your said subject, was then not only strucken down to the ground, but also very sore wounded and hurt by the said Smoote, who, vaunting since in that lewd act, did make his brags that he had thought he had then made your said subject sure, and yet notwithstanding the said Laurence Smoote, not having the fear of God before his eyes, neither regarding your Majesty's laws prohibiting lewd and wilful perjury, about 2 or 3 days after the same battery, he, the said Laurence Smoote, the better to excuse himself of the said battery, did take his corporal oath and gave evidence to an inquest before your highness sheriffs of the said town of Nottingham, that your said subject had then made an affray and bloodshed upon him, the said Laurence Smoote, whereas in truth your said subject, being then first strucken down and wounded by the said Smoote, did nothing but what he could in his own defence, to save himself from further hurt. At which time, if any harm happened to him, the said Smoote, it was in your said subject's own defence.
Shall we carry on? Emma.
May it therefore please your most excellent Majesty, that forasmuch as that those deceits and frauds, unlawful maintenance and champerties in actions, and also such forcible assaults, batteries, and other misdemeanours in churches or churchyards, and also such lewd and corrupt perjuries practised by the said Laurence Smoote, and procured, countenanced, and maintained by the said Christopher Turner, William Barton, Leonard Williamson, Thomas Wilson, John Hanley, Thomas Tomlinson, Henry Pybus, John Richardson, Ralph Nutkin, and James Crosby, are pernicious to the peace of your highness subjects and tranquillity of your Majesty's Commonwealth, and also contrary to your Majesty's good and godly laws established for the preservation thereof. if such offenders may escape unpunished, therefore, to grant unto your said subject, your highness, most gracious writ of Soponia to be directed unto them, the said Laurence Smoote, Christopher Turner, William Barton, Leonard Williamson, Thomas Wilson, John Hanley, Thomas Tomlinson, Henry Pybus, John Richardson, Rafe Nutkin, and James Crosby, commanding them, and every of them thereby, at a certain day, and under a certain pain therein limited, to be and personally to appear in this your highness High Court of Star Chamber, then and there to answer the premises, and further to stand and abide such other order and direction therein, as unto your grace's most honourable privy council shall be thought meet and convenient. And your said subject shall daily pray for the preservation of your highness' estate long to reign and rule over us.
Lovely. Shall we see what Smoote has to say, or has anybody any relevant points or irrelevant points to raise? I'm so proud of you that nobody included Uncle Tom Cobley.
Oh God, the temptation was there.
I knew it was in your minds, Uncle Tom Cobley and all. But no. You should know with all this that lawyers for this were paid by the word. So there's one of the reasons for the list of constant repetition of the list of names. Yes. We are referring to an English folk song. Bill Brewer turns up in it somewhere, but I can't remember all the other names. They're all riding on a horse, aren't they?
Yep.
Sarah.
I'm not about to expand on Uncle Tom Cobley and all. I was just going to say, given that they were paid by the word, it is quite entertaining once you know that on occasion they only mention the first three and they say and the others and the rest or whatever, because it's like in that case it must have just got too much even for them to write out all the names, even though they were being paid extra if they did.
They were restricted somewhat in that they could only write on one side of one piece of parchment. Later on in the reign, and certainly in James's reign, they must have got extra big animals, because the pieces of parchment turn out to be like a banqueting tablecloth. They are enormous, and they are no columns or anything. They are written from the top left corner to the bottom right corner in very small, neat writing, and actually trying to read them without putting your hand on them or leaning on them or it is quite difficult sometimes. But at this period, no, they're not. They're not. Of course, Clerk was making the parchment. That someone was saying, I forget who it was now, it was an eminent legal historian whose name will come back to me, that the history of England is dependent on the deaths of 1 million sheep, which is an interesting way of looking at it. All right. Let us go on to the joint and several answers of William Barton and Laurence Smoote, two of the defendants, to the slanderous and untrue bill of complaint of John Clerk, complainant. And I think it...
The said defendants say that the said bill of complaint is very uncertain, slanderous, and insufficient in the law to be answered unto. For divers very manifest and apparent matters and causes therein contained, as these defendants by their counsel be informed, and is devised, framed, imagined, and set forth by the said complaint of mere malice and evil will, only of intent and purpose to put these defendants to wrongful costs, charges, and expenses in the law, rather than upon any good cause or just grounds of suit, as these defendants taken it. And for as much as the said complainant, at and before the bill exhibited, was and yet it is and standeth indicted for a common baritor, and for that the same indictment yet remaineth in force and untraversed, as these defendants verily think, therefore these defendants demanding the judgment of this honorable court in the premises, whether they shall be compelled to make any other or further answer unto the said bill.
Nevertheless, if these defendants shall be compelled to make any other or further answer unto the said bill of complaint, then and not otherwise these defendants, saving unto them at all times hereafter the benefit of exception to the uncertainty and insufficiency of the said bill of complaint, for answer thereunto say, that as to all unlawful practices, confederacies, combinations, maintenance, champerty, willful and corrupt perjury, assaults, affrays, batteries, riots, routs, and all the other pretended and surmised misdemeanors in the said bill of complaint supposed, with all the said present is in the said bill mentioned, wherewith these defendants or either of them or be charged, that they, these defendants, or either of them are not of the same guilty in such sort, manner, and form as in the said bill of complaint is slanderously and untruly pretended and surmised, without that any other matter or thing alleged in the said bill of complaint, material or effectual in law, to be answered unto and herein, before not sufficiently confessed and avoid traversed or denied, is true. All which matters these defendants are ready to avert and prove as this honorable court shall award, and praying to be dismissed forth of the same with the reasonable costs and charges by them wrongfully sustained concerning this suit.
So it's a blanket denial, dressed up in a lot of legalese. It didn't happen. It wasn't us. He didn't mind. Sarah.
I'm fascinated by the fact that it is dressed up in legalese, because I mean, I haven't read many of these cases with you, but the couple that I've done, the defendants, for want of a better word, I'm sure that's probably not the right word, they tend to be there and they answer themselves. You know, whereas here it's like they've got an actual lawyer doing it for them, which I haven't come across before.
Yes, the answer would usually be written by a lawyer or a clerk, lawyer's clerk. I mean, what he's fundamentally saying is there isn't a case to answer, and if there was a case to answer, it never happened, or it wasn't me. Take your pick. So it's not circumstantial. It just doesn't admit to anything, which leads me to believe that because they're not engaging with Clark's narrative, leads me to wonder what exactly is going on. I mean, Clark has got it, is sending it to Privy Council because you've got conspiracy, you've got riot, you've got assault, you've got all sorts of strange stuff, but none of it is, I mean, it's a con game, it's a fraud. Sarah?
I suppose if they are actually what they claim to be, if they are sort of you know, licensed parchment makers of York, if they're in a guild, then I suppose, is this the early modern equivalent of basically like a really big conglomeration just basically ignoring a suit that's brought by one lone individual for damages because they're so powerful and wealthy that they feel that they can just kind of go, oh yeah, you know what, no, we didn't do it, just, and sort of hoping to sweep it under the carpet, maybe.
Yeah. I mean, the only thing that they do accuse Clerk of, apart from making it all up, is barratry. They say he is a vexatious litigant. But no, I mean, there's no, what would be interesting to know is who these people are. And I haven't the slightest idea who they are. I don't know if they are parchment makers or if they are just mad chancers who will go into a place, do a con, get a bond, and then sell the bond to some likely person in the town and push off to the next town to find another victim. Rachael.
It also makes me, it brings up other things, not just that conglomeration thing that Sarah said, because it seems very much like that, like all the big guy trying to push down on the little guy, but also, you know, all these telephone scams and things like that, you know, like there's a popular one like that people call up the elderly in the US and they say the IRS is sending agents to your house to collect undue taxes unless you give us all your information now, like those types of things. And a lot of those sort of scams, I think, are difficult for the law as it stands now to persecute. And it just reminds me of things like this, that the scam they're running, how that might not have been easy to pin down in terms of the law at the time, or even now, or because I live in New Jersey, the mafia, for how much that the protection rackets they used to run in the 20th century.
Yeah.
That's absolutely, the words protection racket are exactly right. That's basically, these guys seem like a gang. I don't know whether any of them are legitimate parchment makers. If he could prove that they weren't parchment makers, you would think that he would have said that they falsely claimed to be guild members. Laurence Smoote is certainly not a parchment maker. He's their bully boy, it seems.
Well, he's also their dupe as well, because they've basically they've passed the bond on to him, given him the expectation that he can get the money from Clerk, and of course he's never going to. So he's their local bully boy that they've picked, but he's also their kind of, he's their dupe too, as I understand it.
But there's obviously a tremendous amount to unpick here. Now, the next thing we're going to go on to is interrogatories. That is the questions that are put to witnesses. We have interrogatories only by Clerk. So we don't have any by Smoote or any of the other defendants. There are some answers which I have looked over briefly because they are extraordinarily difficult, but they don't appear to give any new information at all. But I think it is rather nice to have a look at the questions that Clerk is proposing should be answered. So if we can whiz through the interrogatories, That will be good. Interrogatories to be ministered unto William Barton, one of the defendants, unto the bill of complaint of John Clerk, complainant.
Imprimis, whether did you, at the time mentioned in the bill, come unto the town of Nottingham, and there tell the complainant that you and the other persons named in the bill, or any of them, had a special license from Her Majesty to make parchment, and whether you have such a license or grant?
And if you have no such, then what moved you to tell the complainant you had one?
And whether did you, or any other, the persons named in the bill, in your hearing, tell the said complainant that all the parchment the said complainant had was forfeited unto you and them, by reason the said complainant had not the like license to make the same by?
And that you would seize the same, except the said complainant would enter into an indenture of covenant unto you and the rest of the defendants, never after that time to make any parchment without the assent and consent of you and the rest of the said parchment makers nominated in the bill, and also enter into a bond to perform the same.
And whether did you and the rest of the said parchment makers then promise the said complainant a license, and what was the cause you refused to make the same according to your promise?
Whether have not you and the rest of the said parchment makers dealt with Laurence Smoote, one of the defendants, to sue the bond made by the said complainant against him, the said complainant?
And if you have, what moved you to so to do?
And whether have you and the rest of the said parchment makers made the said Smoote a letter of attorney for that purpose, and under how many of your hands and in how many of your names is the said letter of attorney made?
And what benefit have you promised unto the said Smoote to have on the recovery of the said bond?
And the interrogatories to be ministered unto Laurence Smoote, one of the defendants, unto the bill of complaint of John Clerk, complainant.
In primis, whether do you know Christopher Turner, William Barton, and the rest of the defendants named in the bill?
And whether have not you and all or some of them dealt together or practiced to put a bond in suit against the said complainant?
And at whose charge is the said bond sued, and what reward or benefit are you to receive upon the recovery of the said bond?
And whether have you not reported that you must have upon the recovery thereof the one moiety to yourself for your labour, and the rest to remain to the other defendants? When and to whom did you report the same, and upon what occasion?
Did not you about the 3rd of November last in the night season strike the said complainant?
And if you did, where did you so strike him?
And whether did you not strike him in St. Peter's churchyard in Nottingham?
And with what weapon did you so strike him, and upon what occasion?
And what hurt did the said complainant receive thereby?
And whether you have you not since that time bragged thereof and reported to them that you had thought you had made the same complainant sure?
And to whom did you so report, and upon what occasion, and by whose procurement? And who were there present with you besides yourself, and what were their names?
Did not you, after you had so stricken and wounded the said complainant, in excuse of yourself, take your corporal oath and give evidence to an inquest before the sheriffs of the town of Nottingham that the said complainant had made an affray and bloodshed upon you?
And what moved you to take such an oath, knowing that you had so sore wounded him, the said complainant?
And what fine did the said complainant pay by reason of your false evidence to said jury as aforesaid, as you know or have credibly heard?
Aha. So we have, strangely enough, a brand new piece of the narrative, namely that the assault in the churchyard went to law before the sheriff's court. For our American participants and listeners, the Sheriff of Nottingham is a real thing. and law and order is what he does. But Robin Hood is not a part of it. Okay. And when he went to the sheriff's court, it was Clerk, who was in the dock, was found guilty of assault and had to pay a fine. So that's interesting. It depends how you feel about the jury. Hello, Sarah.
That is really interesting because the previous Star Chamber cases I've read with you, it's like, oh, well, it could have been this side was telling the truth, or it could have been that they were lying and this side was telling the truth. And I haven't really known which way to jump. Whereas this, I felt so strongly that Smoote was a bad un and Clerk was the innocent, and yet somehow Clerk suffered the penalty, or at least in that particular instance. Yeah.
Yes, it is quite difficult to work out, because there was Smoote going around the pub saying, yeah, well, I fixed him. He wasn't going to divvy up the 20 quid. He was resisting, but I fixed him. Or so Clerk says he was going around the pub saying. I don't know. As with most of the Star Chamber cases, we may never know. But the place to look is obviously in Nottingham and probably also in York. And we've got a question here from Alan saying, was there a guild of parchment makers in York? And that is a question to which I do not know the answer. Alan.
And if there was one, were the named defendants members thereof? And the other one that just struck me is, given that Smoote seems to be a somewhat prominent citizen of Nottingham, how many mates did he have on the jury or in the court that actually decided against Clerk?
Yeah, I mean, these are the Star Chamber project is taking complete chaos and putting it into counties and trying to work out what it's about generally. There may be, I don't know how many thousand cases there are, maybe 30, maybe more. There is no way in my lifetime I'm going to get through them, and there is no way that the project is going to investigate every case. What we're doing is bringing them out into the open and making them available to the local historians. Every time I take a case to a local history society, they know all the names but have never heard of the case. Alan.
Yeah, you mentioned that there are some responses in the documentation you've got, but we've not had them in here.
Mm.
Were they all effectively? No, it wasn't me, Gav, it was 3 other fellas in Yorkshire Terrier.
As far as I have been able to understand it, yes. It's a very, very difficult document and would probably take me about a week to read, which is why I haven't got it. What I've got here is enough to involve local historians, or that's my theory. Okay, now then, have we any more to say on behalf of either Clerk or Smoote, or shall we draw the line under this case? No hands waved. So it only remains for me to thank our wonderful readers and to require you all, as is your bounden duty, to pray for the Queen.